right, everybody. Hi. We're going to get started. My name is Hannah Cartwright, and welcome to what every DOJ rep should know about immigration detention. If you haven't already done your little QR code, it's right over there at the entryway table, so make sure you check in so you get all of your credits for any OLAP renewals and all that good stuff. So my name is Hannah Cartwright. I'm an attorney at Mariposa Legal, which is based in Indianapolis, and we provide detained removal defense representation. So I'm primarily representing individuals who are detained in ICE custody and who are going through immigration court proceedings, usually pretty rapidly. Because immigration detention court usually goes from a beginning hearing to a merits hearing in about 3 months. So much faster than a non-detained court, if you're familiar with non-detained representation, and certainly faster than most USCIS applications, which I know you all deal with on a regular basis. So when Zach asked me to talk about detention, we were sort of brainstorming what is the type of information that you all need to know if you get asked questions, or if one of your clients happens to get detained, or if a family member or a friend of a client gets detained, and really trying to give you all an overview of the system so that you can help folks navigate at least who is the right person to get to next. Okay, so that's really like the idea behind this training. So what we're going to go over today is who gets detained in ICE custody and what are their rights once they are detained. We're going to go over immigration bonds, which are very complex, so this is just going to be like Immigration Bonds 101, but get you some of the basics and have a sense of what to look for if someone comes to you and says, you know, my loved one has a bond, what do I do? We're going to talk a little bit about available immigration relief. So once people are in immigration court proceedings, what they can apply for. This again is just, we're imagining it just as an overview so you can help orient folks. And then ultimately, we're going to talk about what you can do when you learn an immigrant has been detained in ICE custody and actually talk through some hypos. So I'll just start off with sort of explaining how I got involved in detained representation. And one of my first moments where I found out that someone was detained and sort of my panic reaction. So I started out doing representation at a small nonprofit in Philadelphia. And I was doing primarily affirmative representation. So I was doing U visas, T visas, VAWA applications, and affirmative asylum with a little bit of like defensive asylum and immigration court. And so for that job, I was primarily working with domestic violence survivors and doing domestic violence claims, had no context for detention. None of my colleagues were doing detained work. No one really touched it. The closest detention center was about 2.5 hours away in York, Pennsylvania, and so really the only people doing detained rep at that time were private attorneys who would drive down to the detention center and represent people there. So one day, one of my clients came in the afternoon and said that one of their either like cousins or nephews, I forget, some relative that wasn't in the nuclear family was detained, and they were really scared and trying to figure out what to do. Just like they got the news from someone that the person had been detained and were coming to me wanting answers. And I was like, deer in the headlights. Had no idea what to tell them, had no idea where to begin. And I started doing detained rep after that job. So I went to a nonprofit that was in York, Pennsylvania, and began working with the detained, which at the time was the largest detained population in a county jail in the country. So there were about 800 immigrants coming through the jail at any given time. And so I started doing Know Your Rights presentations with those individuals. I started representing people, and I very quickly began to learn the ins and outs of the detained immigration system. And I have often thought back to that moment of being like, oh, there were some tools that were available to you. You just didn't know that they existed. So hopefully with this training going through this, you all will feel empowered to respond to that kind of query with less panic than I had. Does that sound okay? Awesome. Okay, great. All right, so I'm going to throw a lot of vocabulary and acronyms at you, and I figured we'd start with some basic ones. If going through the presentation, I've tried to define any acronyms that I give or introduce sort of a new word that's specific to the detention system. But if I ever use something that you're unfamiliar with, feel free to just raise your hand and just ask me what it is, because you may have already discovered that immigration is alphabet soup. There are so many acronyms, but the detained world, just like the USCIS world, has its own language. And so I'm going to do my best, but feel free to remind me throughout the presentation. So first, I want to start off with orienting you to which subset of the Department of Homeland Security that we're talking about. So you all engage with U.S. Citizenship and Immigration Service, USCIS, probably on a daily basis, right? Sending off applications, probably spending way too much time on the USCIS customer care line, wanting to bang your head against the wall. So that is one part of the Department of Homeland Security umbrella, okay? But the other part is Immigration and Customs Enforcement, or what we call ICE, okay? But ICE really has multiple parts. So you may have heard immigrants in your community referring to ICE as like the people who come and arrest people. Or you may have seen pictures and news articles of like ICE officers with a big ICE on their back going in with police, whether it's on a raid or picking someone up or something like that, okay? That branch of ICE is really enforcement and removal operations, or ERO, okay? But ICE also includes trial attorneys who are actually sitting in immigration court and arguing the cases against the individuals. So we refer to both. So the trial attorneys are really referred to as OPLA, just the acronym for the Office of Principal Legal Advisor. We're going to talk a little bit about them when we talk about immigration relief, but the vast majority of the time, people who are detained in ICE custody are dealing with ERO. Okay? The people who work for ERO are typically called deportation officers. Okay? So those are the people who are dealing day to day with the individuals who are detained, who are handing off documentation, and who are making decisions about who get released and who don't. Okay? So if I refer to ERO or deportation officers, those are going to be the same thing. All right? The second thing that I want to flag is I'm going to use the term detention centers throughout the session today, but really there are multiple types of facilities where people are held in the United States. If you're in a border area along the southern border, there are many large ICE facilities. These are facilities where the Department of Homeland Security, ICE, has contracted directly with a private company, usually like CoreCivic or GEO, which I've listed here, which also tend to run big prisons and jails in various areas in the country. And so the government contracts directly with a company to run an ICE facility, okay? So that's one type of facility. But if you're in what we call the interior in the United States, which is where I've always worked, so places like Pennsylvania and Indiana, anywhere that's not along the southern border, basically, to make it easier on ICE, but not easier on the immigrants going through the system, ICE has contracted with county jails to hold immigrants in ICE custody. So these range from like the facility that's closest to where we are is in Brazil, Indiana, on the western side of the state. It's about an hour from Indianapolis. And the county jail there holds about between 30 and 80 individuals in ICE custody at a given time. Some of the jails hold 800 people, some of them 1,200 people, right? But there it's very weird because immigrants are in a jail with county individuals, so people who have gone through the criminal arrest process and are either waiting for a court hearing or serving a sentence. And right alongside them is individuals who are being held in ICE custody. It gets very confusing as to who has power over them, what's going on, and just what the rules are that individuals who are in county jails are subject to. Okay? But for our purposes, we're not going to dive in too deeply to that. If you ever want to get involved in detention advocacy to try to shut one of those detention centers down, you'll probably learn a lot more about those types of contracts, because attacking those types of detention centers really matters what type of contract and what type of facility it is. But for our purposes today, it doesn't really matter. We're just going to refer to them all as detention centers. Okay? Lastly, we're going to talk about immigration bonds. A bond is a term for an amount of money that an individual is going to pay so that they can be released from immigration detention and continue their immigration court process once they're out. Okay, this is very similar, basically parallel to the bail process in criminal custody. Okay, so if you've ever known someone who's had an arrest, maybe an arrest for shoplifting or an arrest for driving without a license or anything like that, depending on usually a more serious offense, individuals often pay a cash bail in criminal custody, and then they're released so that they can go through the criminal process without staying in a jail. Very similar to immigration. The only problem is fewer people are eligible for a bond in the immigration system than in the criminal court system. So we're going to talk about that eligibility and how hard it is to actually get out of detention. Okay? But being very oriented to bond is very important, because for us as advocates, many of the questions that we get are, how do I get out of detention? Right? So lots of questions about bond come up very quickly in these types of conversations. Okay. Any questions about this terminology so far? Awesome. Okay, so let's start with who gets detained in ICE custody. How many of you have looked at a notice to appear that someone has brought in? Oh yeah, okay. So the notice to appear obviously can be used in a non-detained immigration context, someone who's never been detained, but it really does break down the basics of information even for people who are detained. So I'm going to orient us to a couple of things on that form. So if you remember at the top of the NTA, usually it's biographical information up at the top, but then you may have just kind of glossed over the fact that there are 3 boxes showing 3 types of statuses of basically why the individual is being charged and put in immigration court proceedings. So these 3 boxes also correlate with the 3 categories of individuals who can be detained. Okay? They don't have to be detained necessarily, but they can be detained. Okay? So the first is arriving aliens. I don't like using the term alien, but this is a particular status that we'll refer to. These are individuals who arrived at a port of entry, usually on the southern border, but sometimes elsewhere. Right now I have a client who was detained at the Canadian border, which is kind of interesting and weird, but it does happen. And there are other ports of entry that usually include airports, right? So sometimes people fly in, request asylum with Customs and Border Patrol at an airport, and those individuals would also be considered to be arriving aliens. All right. The second category is non-citizens who entered without inspection, or IWI. That's how we often refer to them. This could be someone who has lived in the United States for a really long time, 10 or more years, 20 or more years. Could also be someone who came in over the border and didn't have a conversation with an ICE officer, with Customs and Border Patrol at the border, and was able to enter the United States and then later had contact with an ICE officer. That could be 5 minutes later, that could be 30 minutes later, 3 days later, years later, okay? But all of those individuals fall into the IWI category. These 2 categories are very interesting because weirdly, you would think that individuals who come in as arriving aliens, who present themselves at the border and ask for asylum, you'd think that they would be treated perhaps more generously than individuals who effectively evade detection when they come in to the United States. But weirdly, the law is the opposite, not intuitive. And so individuals who are in the arriving alien category, they will be detained and not eligible for a bond. Whereas individuals who are in the IWI category will also be detained, but they will be eligible for a bond. Weird, right? But that's the first of many non-intuitive things about our detention system. The last category is non-citizens who were inspected and admitted, but whose status has lapsed. So this could be a student who who ran out of money and wasn't able to finish their school. It could be someone with a green card who has violated their status by being arrested or getting a criminal conviction. There's a variety of circumstances, but in general you want to think, okay, this person had some type of status, but they either lost it or are about to lose it. Okay, so then they end up falling into the category of undocumented. Okay? Yeah.
Quick question
Yeah.
about the second one.
Yeah.
So it says like you're often picked up after a traffic stop or criminal arrest. I guess it's like a two-kind of question. Like, who would make that arrest? Would it be like the police officer or would it be ICE? And then what happens in a sanctuary city? Like, are they even allowed to do that?
Yeah, very good questions. So it does depend on both whether it is a sanctuary city, a sanctuary jurisdiction, and what type of sanctuary protections there are. So typically a traffic stop is going to be the police, not ICE. So you can imagine whether it's, the person is speeding or, going over lanes, the police have to have a reason to stop the person. Obviously there are issues of racial profiling that happen. There are particular counties in Indiana where I practice where it's very common for people to just be picked up because they're brown with an excuse for why. But that's all really going to be police. And then after the person is booked into the jail, that's when information gets sent to ICE if it's not a sanctuary city. So usually the booking information is very basic. It's like name, birth date, what country were you born in. And that right there is enough for ICE to put them on a list to interview. So sanctuary cities or jurisdictions that have policies that prevent ICE from picking people up after an arrest can effectively stop that. ICE may still get that information, but then they have to do their own investigation to pick the person up later. So going to that person's address, etc. That make sense? Yeah. We could talk for a whole session about the connection between police and ICE and the very blurry lines with all of that. So we can talk more about that in question and answer if you guys are interested. Okay, so once someone is detained, okay, so people in these three categories, okay, ICE has the discretion not to detain all of these people, but they make decisions to detain people because they can. All right, we could go into profit motives as well, but for now, people can be detained. So once people get detained, what are their rights? Okay, so this is where it gets really murky because people can be detained and actually be put in multiple different processes. And which process they are put in depends on how many rights they have. Okay? So pretty much everyone, regardless of the processes that they're put in, has the right to be served with paperwork with the allegations against them. Okay? Unfortunately, there are no language access rights. So these documents are all going to be in English. So their ability to actually understand the rights understand the documents that have been served against them and what allegations that ICE is bringing is very limited, and this level of confusion happens all the time with people who don't have representation, even with people who do have representation and are trying to navigate the world if English isn't their first language. For non-citizens who are put in removal proceedings, this is basically if they're put in immigration court proceedings and an NTA is filed against them. Okay, so if you see someone who has a notice to appear, that means they get to go to immigration court. That means they have due process rights, at least some limited rights. And it means that they will see a judge, and a judge has to make a decision in their case. Okay? People in these other processes that I've named up here, for example, people who have a final administrative order of removal or a FARO, people who are put in withholding only proceedings, there's something called reinstatement of removal. I'll go through some of these categories on the next slide. all of those individuals are pretty much going to just be cycled out of the country and deported. They're not going to see an immigration judge. Okay? And these types of processes have been increasing over the last 10 years as presidential administrations have become more and more focused on how do we get people out of the country very fast. Okay? So that's one of the big problems in this area, is that many of the people that you hear are coming over the border are actually being removed so quickly that they don't actually get a chance to talk to an immigration judge or explore their claims. All right, so the main thing to keep in mind is that the number of people who may be calling you or your offices and saying, what do we do if someone is detained? One, you want to try to figure out, are they in the immigration court process or not? Most of the time, if they're in the interior, they are going to be in the immigration court process. But if you're close to a border, that gets really murky. Okay? So just be aware that multiple processes exist and that you're trying to kind of figure some of that out. All right? If an individual is put in removal proceedings with the immigration judge, these are the rights that they have. As you can see, it is not a very long list. Okay? You basically have a right to have a court hearing, to examine evidence that's filed against you, which the first piece of evidence is always the notice to appear. You have the right to hire an attorney, but not to have an attorney for free. So there's no public defender system in the immigration court, both non-detained and detained immigration court. You have the right to have an oral interpreter, but you don't have the right to have the documents translated for you. So that's special and not intuitive. You have the right to appeal a decision of the immigration judge, and you have the right to make a bond request, whether you're eligible or not. Okay? So the categories of people who don't have the right to see an immigration judge and thus don't have those rights that I just went over are in these categories. Okay? So one of the most important ones to remember is if someone already has a deportation order, ICE is going to use that deportation order and execute it now, and they're not going to see an immigration judge. Okay, so one of the first questions that I typically ask is, does the person who's been detained, have they ever been deported? Okay, because that's going to matter, especially, for example, people from Mexico. In Indianapolis, if someone has a prior deportation order, if they're picked up on a Monday or Tuesday, by Friday, they're likely going to be deported back to Mexico. So that can happen very, very quickly. And so identifying whether someone has a prior order is really important. So that's number two. The first one that I refer to is when someone has been previously deported. The difference between these two is one person has actually been deported and left the United States, whereas the other person got an order of deportation but remained in the United States. Okay? Either way, ICE can deport them very quickly, but it's a slightly different process. All right? In certain circumstances where individuals have serious crimes, one of the categories that you may have heard of in the USCIS context as well, depending on if you ever have encountered individuals who have criminal convictions, is if someone has an aggravated felony, ICE can remove them through a process called the final administrative removal order, and again, they will not see an immigration judge. Okay. Last but not least is this process called expedited removal. If you've ever read a news article that talks about the increasing numbers of people who are basically expelled from the United States, they're typically going through that process. So, as the summary says at the bottom, there's lots of ways for ICE to deport people, okay? Even without seeing an immigration judge. So orienting people to that is really important. Yeah?
Mm-hmm. But they do have the right to hire an attorney.
Yeah.
So they do get their free phone call?
Yes, the vast majority of the time.
And
yes.
So they will be provided with like potential list of people then?
So if they're going to the immigration court, so if they're put in removal proceedings, one of the papers in the packet will be a list of low-cost legal service providers for the area where that immigration court is. Typically, it's like 1 to 3 nonprofit legal service providers that have their contact information on that list, but that's all they'll be provided. Yeah. Okay, we're not going to spend very much time on this, but the intersection of criminal law and immigration law is super, super complicated, okay? So in general, when the likelihood, especially for someone in the interior, if they have been detained, is that they likely have an arrest or a conviction, okay? And just that right there is putting you into a situation where you really want to get an attorney involved as soon as possible, okay? Because the consequences related to criminal convictions can get really murky and can be really hard to step back from. So you can actually end up doing a lot more damage going into, even if you're trying to help someone, than if you just didn't do anything, okay? Because if no one does anything and the person is proceeding pro se, if an attorney gets involved later, there are things that an attorney can do to appeal certain issues, right? But if there is a legal representative involved advising the person or making certain decisions, then that can actually undo some of those options for people. So just in general, if you see a crime, a criminal conviction, then we'll go through like what type of attorney to refer people to later in the presentation. But if you hear crime, you want to think, how can I refer this person to someone who has specifically a crimmigration practice, someone who is really looking very closely at the immigration consequences of criminal convictions, often in the particular state where the person's conviction has happened or the arrest has happened. So it gets really, really specific and a really kind of highly specialized area, okay? So I consider myself to be a detained removal defense attorney, but I do not consider myself a crim expert, even though I deal with people who have criminal convictions all the time, right? So there are people who specialize just in crim all the time. And you wanna try to find one of those people if possible. Okay, so let's talk a little bit about immigration bonds. So who's eligible for yeah?
Is there like a guild or group of those types of immigration attorneys that we can find where they're listed?
No. So I'll give you a couple potential groups that you can at least narrow it down, but there's no like subset of like these are crimmigration attorneys. That would be really lovely. But no, that doesn't exist. So that is one of the things that can be really challenging about referring people out, is trying to figure out the right attorney to go to. Okay, so we'll get to that at the end. Okay, so who's eligible for an immigration bond? So we have these three categories of non-citizens who can be detained, right? Which of those three categories are people who can actually request and get a bond? Okay, so basically the way that the INA, the Immigration and Nationality Act, sets this up is it gives one section that says these are people who are subject to what's called mandatory detention, okay? Meaning that the judge doesn't get a say in whether or not they get a bond, they have to remain detained, okay? And then the other section says anybody who's not listed in one of these mandatory detention categories, they can get a bond, okay? So it's kind of, again, it's not intuitive, but you're doing sort of an exception. If they don't fall into here, then they can ask for a bond. And then individuals who can ask for a bond, or what we call statutorily eligible to ask for a bond, have to prove two things. They have to prove to an immigration judge that they're not a flight risk, meaning that if they get released, they will actually go to the court hearing in a non-detained court. And secondly, they need to prove that they're not a danger to society. Both of these are very subjective standards, and there's lots of arguments about both of them. People can prove that they are not a flight risk and then lose on a bond, not get granted a bond because they're found to be a danger to society, and vice versa. Okay? So a couple things to keep in mind of people who are not eligible for bond are these individuals who are subject to mandatory detention. One of the most important ones, obviously the three in the middle, are all having to do with crimes. So just in general, if you see someone who has a crime, you're like, we need to refer this person to a criminal specialist, an immigration attorney who can determine, is this person going to be eligible for a bond or not? Or is that crime going to cause problems? All right, but for our purposes, the first and last are really important, okay, because we can be issue spotting even in our roles as accredited reps. So the first is all non-citizens considered to be arriving aliens. So like I mentioned on that slide where we were looking at the 3 boxes, people who arrive and ask for asylum at a port of entry are not going to be eligible for a bond. So if you see that first box checked, you already know, okay, this person is not going to be able to be released. Okay, we'll talk about in a little bit, there's a sort of parallel process called parole. And so some individuals are paroled in. They can make a request to ICE to be released on parole. There are certain areas of the country where parole happens, and then other areas of the country where basically parole isn't an option, okay? But that is a decision totally by ERO and the deportation officers, so there's no one, like there's no appeal option, there's very little due process rights related to that, whereas bond at least is a little bit more protected. Lastly, individuals with prior orders of deportation, okay? So there are certain circumstances where people who have been previously ordered deported can reopen their cases, okay, in very certain circumstances. But those individuals, even if they somehow remain in court proceedings, they're not going to be eligible for a bond because they've already shown effectively that they have not, that they've violated the law in the past. Okay? All right, so who gives immigration bonds? There's 2 bond determinations that happen. The first bond determination happens by ERO, by the deportation officer, at the time that the person is detained. And usually a person who's detained is carrying around like 4 to 5 pieces of paper, and one of the pieces of paper is usually the bond determination. There are some parts of the country where ICE ERO does actually give bonds. Sometimes it's a $5,000 bond, sometimes it's a $10,000 bond, but it tends to be cases that are very, very straightforward. In my opinion, usually cases where the person shouldn't be detained in the first place, okay? But that is one option for ICE to give a bond at that time. So that would be a circumstance where someone might come in and give you copies of paperwork, and you might actually see, okay, this person has a $5,000 bond. The vast majority of the time, ICE does not set a bond, and then there has to be a custody redetermination in front of the immigration court, all right? This only happens when the detained individual makes a bond request. Okay, so this is a person's right to make the bond request, meaning that they shouldn't make that bond request until they're actually ready. Okay, this is important because an individual only gets 1 bond hearing, or as you can see in my beautiful photo, 1 bite at the apple. Okay? It's very hard to find pictures for detained slides, so I was really happy when I found one of someone taking a bite of an apple. So this can be very challenging because people who are detained usually want to make a decision about asking for bond and getting released usually in the first 10 days of detention because people hate being detained and they want to make a decision about whether they're going to get deported or not. But making a decision about and like gathering all of the evidence for a bond hearing usually takes longer than those 10 days. So those 2 timelines really butt up against one another a lot. But especially if it's a complex bond hearing, it can be important to actually wait until the person has an attorney so that they can gather evidence to really show that they're eligible for a bond. If the person does a bond hearing on their own and then gets an attorney and later makes another bond request, the immigration judge will set it for a higher standard and they will have to show changed circumstances, which typically is only like if they've gotten immigration status now, or something huge has changed in their country of origin, or something like that. It's not just, I got an attorney, or now I have the evidence, now I have letters of support, etc. Question?
Does money actually change hands in this?
Yes. So let's just look at this. So a minimum bond is $1,500 in the immigration system. An immigration judge or ICE can't set something lower than that. There's technically an option for release on your own recognizance, but it hardly ever happens. There's no maximum, so there are certain areas of the country where it's not uncommon for a $15,000 bond, a $20,000 bond, a $25,000 bond. I think the highest I've gotten in a court in Arizona was like $18,500, and I was told that that was like a good bond in front of that judge, which is incredibly frightening. So In terms of how it happens, so once the bond is issued either by ICE or the immigration court, then the bond has to be posted. Okay, this is again parallel to the cash bail process in criminal custody, except you're paying it to ICE, you're paying it to the Department of Homeland Security. These days, the process for paying a bond in person is kind of being phased out, and there's a new electronic bond process that's really problematic called CE bonds. But in general, a person who has a bond, who's been granted a bond by ICE or the immigration court, has to have someone who has a green card or citizenship in the United States who can post the bond for them. That person is an obligor, and that person is kind of considered to be a sponsor. So it's a three-way contract between the person who posts the money to the federal government, the person who's required to, or who's going to be released and is required to go to court, and the person who has posted the money is basically promising that if that person doesn't go to court, they will turn them over to ICE. So it does create some kind of fractured relationships between families and communities at times. A lot of times it goes fine, but that's how the money gets exchanged. Once the money is actually posted to ICE, then the person will be released from detention. Usually it's a money order or a cashier's check, so it's not cash.
Are there bail bondsmen like in regular criminal court?
Yes, you guys are asking such good questions. So there are a couple private bond companies. They typically charge an interest fee on top of it, and they're typically very predatory. So I've purposely not put their names up on these slides. When you're working with individuals, if you happen to if someone brings in paperwork and they're frantic and you happen to look and it says this person has a $5,000 bond, I really encourage you to try to connect with nonprofit bond funds, especially if one exists in your area, to see if a nonprofit bond fund can help. These are revolving funds, so basically a nonprofit will post the bond for one person, then once that person's case ends, the money comes back to the bond fund, and then it goes to help another person. And typically they're very open to, regardless of a person's criminal conviction, regardless of a person's status, and they're going to be much less oriented towards surveillance and other problematic behaviors. Someone else had a question? Yeah.
So in cases of a family person who is sponsoring for this bond,
Yeah.
they have the obligation to turn them over. But if they're unable to, what happens to the obligor?
So nothing happens to the obligor, but if the person doesn't complete the immigration court process and doesn't get deported and go back to the consulate and say, okay, I'm back in my home country, then the obligor is not going to get the money back. So that's where it gets to be kind of fractured relationships, is when the family member or friend or whoever has put up the money wants their money back, and the other person is not necessarily wanting to go to court, or other things come up and the person can't make it to court. There's all sorts of circumstances where that can get a little dicey. Okay, I'm going to go back real quick, but these all questions are really good. So back to thinking about the bond hearing, okay? Even though I know it's a lot to think about, whether someone's eligible for a bond, how all of the bond payment process works, we don't want to lose sight of the fact that actually having a bond hearing can be really hard. And this is where, again, sometimes advocates get questions about, well, what kinds of documents does an immigration judge need to let my loved one out, okay? These are things that you don't need to feel like you need to advise. It's outside of your role as an accredited representative, but it can be helpful if someone comes to you and is like, well, I'm talking to an attorney and the attorney says that I need to give a letter of support, if you at least have an idea of what that letter of support is, okay? So typically, to show that a person is not a flight risk, you're typically trying to show that the person has family ties and other types of ties to the community. So one of the easiest ways to show that is by letters of support from family and friends saying, I know this person, I've been in a relationship with this person for X amount of time, this person is a person of good moral character, I want this person to stay in the United States, all of that kind of thing, okay? Describing the type of relationship. This can include letters from religious leaders, from leaders of their congregations, community groups, prior employers, anything to show that this person has ties to the United States that shouldn't be disrupted by deportation. Secondly, when you're trying to show that a person is not a danger to the community, you're looking at any documents showing any rehabilitation after a criminal conviction. So I give the example here of like if someone has their first driving under the influence conviction, or maybe like a second conviction. If they show that after their first conviction that they went to Alcoholics Anonymous for a little while, or they did some kind of rehabilitation program, some of that can be helpful in showing the likelihood that the person won't get arrested for driving under the influence again. Sometimes if there's a crime that involves a victim, whether it's a child or a spouse or another family member, especially if it's a misunderstanding or something that perhaps the police got involved, like if someone else called the police and the victim wasn't wanting the police to be involved, sometimes a letter from a victim may also be relevant. All right, so just in general, what you want to know here is that this type of evidence gathering is really important. Getting an attorney involved early on so that they can help the family decide if they want to go for bond and to gather this type of evidence is going to be really important for two reasons. One, it may be the difference between getting a bond or not, okay? Which for many people is the difference between getting to stay in the United States, period, or not. Because it's very hard to win applications for relief in detained immigration court. But the second thing is that it's also going to matter how much it's also going to be relevant to how much that bond will be. So if you're working with someone who's low income, which I know many of you are, they may be like, well, I could pay a bond that's $1,500, but if the judge sets a $5,000 bond or a $7,500 bond, there's no way we can make that. And maybe you're in an area where there isn't a nonprofit bond fund. So if your only chance at getting a bond is to have a low bond, it's very, very important for the detained individual to go into a bond hearing with all of the evidence that they would want, and ideally with an attorney. It can be done without an attorney, but even just getting evidence through a detention center can take a lot of time. So in general, having an attorney to guide people through this process is really important. Okay, so are there other ways to get out of ICE detention besides bond? I already mentioned parole briefly. We're not going to talk too much about it, but it's a very similar process to bond, except instead of talking to an immigration judge, you're writing a cover letter, sort of similar like a petition that you would send to USCIS, including any evidence, and you're sending that to a deportation officer and hoping that ERO will actually make a decision on it. Because there are no due process rights related to that, people can often send requests for parole in and not hear back for months or just never get a response back. In the area that I practice, so I'm based here in Indianapolis, primarily working with the Chicago Immigration Court and the Chicago ERO office, parole requests hardly ever get granted. Some of them were granted during COVID, like the very beginning of the pandemic. But other than that, I hardly ever put in parole requests because it's a waste of time. They never grant them. Okay. There's in other areas you might hear about people being paroled. Sometimes like very specific populations, like Cubans, can get paroled. But those are because of specific like diplomatic situations. So if the person can't get a bond or isn't eligible for a bond or the bond is too high and they can't get parole, then the only way to get out, if you're not going to accept a deportation order, is to apply for relief from removal. Oops. How are people feeling? Overwhelmed yet? Yeah.
Trying to think over all this process, what happened to the children that come with these families? And when families come and are detained, do they separate the family? Like, what's the process there?
Yeah. So I'm far from an expert on that because I don't work along the southern border. But basically the policies related to family separation have changed a lot over the last 10 years. There have been times where families have been separated, most notably during the Trump administration, where individuals would come in and the children would be put in a shelter. Children's shelters, even if they're called shelters instead of detention facilities, they're not jail settings, they're not ICE facilities, they're run by the Office of Refugee Resettlement under the Department of Health and Human Services, HHS, I think that's right. So it's a different entity that's detaining them, different dynamic. The shelters are going to look more pleasant. Many people would argue that it's still detention for children, but it's possible that the child will be completely separated from the parent that they've come in with. There have been efforts to keep families unified. So one thing that can happen is that they can go to a family shelter, in which case usually the child is with at least one, if not both parents, depending on who came in. And then oftentimes if a whole family unit came in, then the one parent and the child will be released and the other parent will be detained. So it's very common for a mother and child to be released and then the father to be detained and them to be in completely separate processes. So long story short, a lot of different things can happen. There is sort of political drama right now because the Biden administration is creating more family shelters at the southern border and has created some new processes that I haven't really kept track of. But certainly there's still family separation happening. It's just at a different scale than it was during the Trump administration.
Since we can't represent people in detention facilities, like we get clients who were detained but aren't in removal, but like talk to us about like pretty bad like conditions. I know this year or last year the Office of the Immigration Detention Ombudsman was like enrolled, whatever. Are we able to like file any complaint after the fact?
Yes. So that is one of the few things, I didn't really talk about it, but that's one of the few rights that all individuals in detention, regardless of which type of process they're in, they do have the right to file a complaint with two entities. It's the Office of Civil Rights and Civil Liberties under the Department of Homeland Security and the Office of Inspector General. And those would be, you don't have to be an attorney to file those complaints. There are complaint forms that you can fill out, and they absolutely can be filled out both during detention and after detention. It can often be very hard. The Ombudsman office that you're referring to is a fairly new creation under the Biden administration. So they're trying to make it easier for people while they're detained to make complaints. But there have been all sorts of like bugs in the process, people like ICE officers finding out about complaints getting made and then intimidation happening, like it's just a whole mess. So it's often actually safer for people to make complaints after the fact. So I don't really know. I mean, I think that would probably be something to talk about, as a organization, whether that's something that Immigrant Connections would be interested in filing those types of complaints. But there are definitely like samples, and it's a combination of like basically a cover letter describing what happened, usually an affidavit from the person describing what happened in detention, and then any additional like articles about the particular detention center or things that have gone on. So like we filed one recently for someone who was detained at Stewart in Georgia, which is like one of the most harrowing detention centers in the country and has long been on the list of facilities by advocates that need to be closed. So we included in our complaint evidence from other people that had filed complaints that had gotten into the news to really sort of like be corroboration. But yes, they can definitely file those complaints.
What about the ORR shelters?
I know less about that. I would assume that there's probably a corollary, like Office of Inspector General for HHS. Because they're different facilities, I don't actually know the answer to that question. Yeah.
So you mentioned that getting a bond or not could be the difference between whether they get deported based on which court they're in. Can you expand on that just a little bit?
Yeah. So, well, let me go to this slide, and I think I'll be able to answer that question. So, if the person doesn't get a bond and they don't want to accept a deportation order, they're going to have to apply for a defense to deportation, or what we call relief from removal. As you can see, there's not a long list, right? It's not like the long list of visas that are available to people. There's people who are non-detained, even though our immigration system doesn't give a lot of avenues to like getting a green card or different types of relief. People who are detained really have a restricted type of relief to go after, okay? And it's really the top 4 here that are really gonna help the vast majority of people. And depending on which court you're in, depends on your chances of getting this type of relief. So how many of you have heard about the like ratings for immigration judges that talk about how many asylum applications they've granted or denied? Many of you seen that data? Okay, so there's data that gets released from the immigration courts, the Executive Office of Immigration Review, every like month or every quarter, and it goes through and says how many individuals have been granted asylum. And about, I think like 20 years ago, someone did a documentary about kind of like asylum roulette, basically, and have shown correlations between, you know, certain immigration judges, often dependent on their backgrounds, but sometimes even dependent on what type of day it is, and like what time of day it is, and like whether they had lunch and different things like that will impact whether or not they're going to grant asylum or not. And it's not just asylum, but asylum, withholding of removal, and protection under the Convention Against Torture. So advocates have long looked at that as a litmus test for what type of immigration judge is this going to be, and like what's the likelihood of chances on all types of relief, not just asylum. It's not a perfect test, but in general, you know, for example, at Stewart, the immigration judges have a like 99% denial rate for asylum. So if you think about that, you're like, okay, whether you're applying for asylum or cancellation of removal or adjustment of status, if those judges are denying 99% of the claims that are in front of them, you're probably not going to win, right? You might be that 1%, but you're probably not, right? And that probably reflects the immigration judge's interpretation of the laws, and likely reflects like which side of the political spectrum that you're on and various other things. So there are, at Syracuse University, there's a data center called TRAC. It's like the Transactional Records Access Center. And so they literally do a profile on each immigration judge that gives their rate based on the data of how many asylum applications they've granted. So you can literally look up based on the immigration judge when they were appointed, which president appointed them, and what their asylum grant rate is. So if you happen to be detained, we'll just keep going with Stewart for now, in Georgia at the Stewart Immigration Court, and you're looking at 3 or 4 judges, and they all have 99% denial rates, or maybe at least all in the 90s, your chances of getting out of detention and not being deported are so much lower than if you're in the Chicago Immigration Court or the Arlington Immigration Court, where the denials are more like 60% or 70%. Still very high, but there's much more room for people to actually get some type of relief, okay? So that's what I mean in terms of like people who can get a bond get a chance to get out of court and move to a different area where maybe the grant rates are higher. It also gives more opportunity to gather evidence for your claim. Doing so in detention is so hard that it makes those cases even harder to win. And then some of these other types of relief that we'll talk about in a second, like cancellation of removal or adjustment of status and waivers, they require a lot of the types of evidence that you're more used to looking at, okay? Evidence of showing like hardship to family members, evidence of like how long you've lived in the US, or family ties, tax returns, all that good stuff. All of that is super hard to gather while you're detained, and sometimes you just need more time to, like for cancellation of removal, for one of them you have to show exceptional and extremely unusual hardship to a qualifying relative. Maybe your qualifying relative has a medical issue, but you haven't been able to get like a full diagnosis yet, or you haven't been able to get treatment or really understand like the scope of why that person would suffer hardship. So you may need to get out on bond so that you can develop your claim, okay? People who have weak claims also, just in general, the more time that they have to get additional evidence for things to shift, bond is going to be better. Okay? Okay, so I've already kind of highlighted some things about defenses to deportation here, but just to go over them briefly. So one option is derivative citizenship. If you can somehow prove that you're a citizen, then that is the ultimate defense to deportation because they can't deport you. But just to give you an idea, I've been practicing for 10 years and I've had one derivative citizenship case, and it's still pending with USCIS because NATS applications are taking years. So it's very, very rare. There's a variety of ways to prove derivative citizenship, but it's usually through your parents, and it almost always has to happen before you turn 18. Some of that depends on like which year you came in. We're not going to go through all the derivative citizenship requirements, but it's there, but very hard to prove. Cancellation of removal, there are 3 types. One is for people who already have a green card and have committed a crime that's violated their green card status, and they're applying to have their removal canceled so they can keep their green card and stay in the United States. Okay? There are time requirements for cancellation of removal. So for the ones for green card holders, you have to have been in the United States for 7 years, and you had to have had a green card for 5 years. So if someone gets detained and they have a green card, but they've only had their green card for 4 years, no dice, okay? They're not gonna be eligible for that. So cancellation of removal can be a huge thing for people, but it can, because of all of these like very specific time requirements and different requirements related to crimes, it can be very difficult to get. What else was I going to say about that? All 3 types of cancellation of removal, people can only get 1 time. Okay, so if a person is detained for a second time and they previously got cancellation of removal, they can't apply for it again, and they would have to apply for something else, which especially on this very short list means you're really running out of options. Okay. Cancellation of removal for non-lawful permanent residents, people who don't have green cards. You have to have been in the United States for 10 years. If you've ever heard people refer to like a 10-year green card, it's usually like people really watering down the law and referring to cancellation of removal. It's very hard because not only do you have to show 10 years in the United States, you have to show that you're a person of good moral character, which means you can't be convicted of certain crimes. Like if you have a drug crime, you can't get cancellation of removal. We have a huge epidemic of substance abuse in our country, so that, you know, gets a lot of people out of eligibility for cancellation of removal. Then you have to have a qualifying relative. This has to be a parent, spouse, or child that's a U.S. citizenship or a green card holder, and they have to suffer exceptional and extremely unusual hardship. And there has to be evidence of that in order for them to get cancellation. So you could live in the United States for 10 years, have tons of family ties, and if your family is all healthy and don't have any like learning or development issues, don't have any disabilities, no one has like a cancer diagnosis, then you're not going to get cancellation of removal. Okay, so it's a very high bar. There used to be something else called suspension of deportation back in the day, and too many people were getting suspension from deportation. So Congress, being the great folks that they are, went in and created this new type of relief called cancellation of removal. And I like to think that someone was drunk when they came up with this standard of exceptional and extremely unusual hardship, which is both a mouthful to say, but also just ridiculous, right? To basically say to individuals who have lived here for a long time, who have all of these family ties and who have U.S. citizen or green card holding family members, to say that this is the only time that you can get this relief, okay? As you can see, I'm probably not the biggest fan of the Immigration and Nationality Act as it is. I have a lot of critiques, and that is one of them. We won't go through VAWA cancellation, but there are basically, for domestic violence survivors, there's some modified requirements for cancellation or removal that makes it a little bit easier for those individuals. You all will be familiar with asylum. Obviously, you can apply for asylum in the affirmative context from USCIS, but you can also apply for asylum with the immigration court. When you're in immigration court, you can also apply for the two kind of sister types of relief, withholding of removal and protection under the Convention Against Torture. It's all in the same form, the I-589, but it's particularly helpful for people who have criminal convictions, because for asylum, you can't get asylum if you have what's called a particularly serious crime. And for people who have withholding, or for people who get withholding of removal or protection under CAT, depending on their criminal convictions, they can still get that kind of relief and remain in the United States. So there's also adjustment of status. Typically, that's being applied for, a green card application with a waiver that can waive certain types of crimes. But that process takes a really long time because you're still going through USCIS, and so the person has to sit in detention while the application pins with USCIS. So that's where you get into people being detained for like 9 to 12 months, and that's with no appeal. So that can be really challenging. Every once in a while, there are certain areas of the country where people can actually apply for U visas, TV visas, VAWA, while they're detained. Also, really long wait times and very, very difficult. I do some of these cases, and I sometimes think it's not even worth applying for, but there are ways to jump the U visa line if you file a U visa in detention. So that is somewhat appealing sometimes. Last but not least, if you aren't eligible for one of these defenses, then you can apply for voluntary departure. Voluntary departure means that you're not going to have a deportation order on your record, but and instead of the consequences of a deportation order, which usually means that you can't apply to come back to the United States for 10 years, this lowers it to either 3 years or 5 years. And so you can then apply to come back after that period of time. So it really only helps people to take voluntary departure if they have a family member in the United States who can petition for them in the future. Okay, so say I have someone who's detained who has a child who's 16 and is going to turn 21 in just, 5 years. So if a person takes voluntary departure, and then they have a 5-year bar, then if the child petitions for them at that 5-year mark, then they're going to be able to try to consular process and come back to the United States. For people who don't have anyone to petition for them, voluntary departure is pretty much unhelpful. Okay? So the main thing, what are the takeaways here? The main thing to know is it's really hard to get any type of relief in immigration court, but there are some avenues available, right? So if a family or a pastor or community member is saying, this person is getting detained, or this person got detained, I don't know if they're going to be deported, even saying something like, well, it's really complex, but there are things that someone can apply for if they are in front of an immigration judge. So it's worth talking to an attorney to find out what the person will be eligible for, right? That is definitely very true, and applying for these types of forms of relief keep people in the United States all the time. Okay. All right, so I know it's 11:20. Do people need to get up and move around at all? Are you guys feeling okay? Hard to know? Well, feel free. If you need to go to the bathroom, if you need to go in and out, we'll keep going, but it's not going to hurt my feelings. So. All right, so what can you do when an immigrant is detained in ICE custody? So especially in your positions as partially accredited representatives, what can you in your role actually do in these moments? If you think back to my example at the very beginning where you're doing your normal petitions for USCIS and then someone comes in and throws this curveball at you, what can you do to not panic in that moment and to provide some assistance? So I'm going to go through the list, and then we're going to go one by one to sort of walk you through what you need to do for each of these. So the first thing that you can do is work with the family member or pastor, whoever is bringing this information to you, to try to verify that the person is actually detained in ICE custody. Okay, and we're going to talk about how to do that. You can help family members and friends of the detained person gather key information so that by the time they talk to an attorney like me, they actually have the information that the attorney needs. That's going to speed things up, especially, the time is ticking as soon as a person is detained, and my anecdotal evidence is people usually make decisions about what they're going to do, whether they're going to fight their case or not, in the first 10 days, sometimes the first 3 days. So really getting that information together quickly could really make a difference. If you can, try to find out how the person was detained, whether there was a traffic stop, whether there was an arrest, whether the person came over the border, whether ICE came to the person's home or ICE came to the person's work. That can also be relevant to what an attorney is going to, the types of questions that an attorney is going to ask in a consultation. So that can be really helpful for your referral. We're going to talk about how to make a warm referral to an immigration attorney who could potentially actually represent them. So we're not talking about like just giving them a list or necessarily even just helping them look online for like places that might do detained rep, but actually getting to a like shorter group of people who are actually doing detained representation and who could actually consider taking the case depending on their caseload. And lastly, if you happen to come across a person who has a bond, you guys can be very helpful in helping navigate the process of trying to get their bond paid, especially if there's a nonprofit immigration bond fund nearby or a national one that can assist. Those typically have very low staff. Many of them are run by volunteers, and so having a sort of like contact or helper on the ground, especially that can interface with a family, can be hugely helpful. Okay, so how do we attempt to find an immigrant that we think is detained in ICE custody? So I often get reports that someone is detained in ICE custody, and it turns out that the person is not actually in ICE custody. So this is kind of a trick situation. So this is what the ICE Online Detainee Locator system looks like. If you pull it up on a website, here's the link here. There are 2 ways to search the system to try to find someone. The first one is if you have the alien number for the individual. The second, and also their country of origin. The second is if you have their first name, last name, date of birth, and also the country of origin. As you can see, there's a whole list of things to try if the person doesn't show up, because this tool is very unreliable. And it's also dependent on what exactly the ICE officer put on the person's record. So say they spell, I'm trying to think of a good example. Say the person's last name is Perez, and instead of spelling it with a Z, they spell it with an S. If you put in Perez with a Z, it will not pull up that person. Okay, so there's all sorts of like problems in the database that can make it very difficult to locate someone. But if you get lucky, and if you actually have the A number and the correct country of origin, if you get lucky, this will pull up the person's name and which detention center they are at. So if you're sitting in your office and someone comes in frantically, if the person has that information, you might be able to give them the good news of like, we know where this person is. The person is still in the United States. You know, here, let me help find the contact information for that particular facility. All right, so this can be a helpful tool. You just need to know that it's also wonky, okay? The main thing I want to flag here is that sometimes people don't show up in the online detainee locator, but are actually detained in ICE custody, but are being transferred from one facility to another. So transfers between facilities are very common, and if the person is being transferred, they won't show up, but maybe the next day they will. Okay, so also being conscious to tell family and friends, okay, they're not showing up right now, but it's possible that they're being transferred from a county jail to an ICE facility, or from one ICE facility to another ICE facility, so let's check again tomorrow before we panic. Okay. So a couple other things that you can do to try to find them on there. The best way to keep track of a person in ICE detention is to have the A number. okay? So if you have someone come in and say this person is detained, the first thing is to figure out, can you find the A number without talking to the person? I think it was you who asked the question about a phone call. So oftentimes the first phone call people will make, rather than to an attorney, because many of them don't have an immigration attorney, is to a family member to say, I've been detained. But they don't necessarily know that they should provide their A number to that family member in that first call. If they don't know it's important, why would you think to provide that number, especially if you've never seen an A number before?
But isn't that like a catch-22 because these are usually EWIs? People actually qualify, so they likely cost instead of getting an A number through inspection.
Yes.
So they may actually not even have an A number to begin with.
Right, but as soon as they get put in ICE custody, they will be assigned an A number.
Okay.
So one of the things that I can do is like, if someone's very recently come across, usually their A number starts with like a 2-4 right now. And so if you see someone with a very high A number, it's usually someone who's come across very recently and they've just been put in the system. Whereas someone who has an A number that starts with like a 0-9 almost always has a green card because it's a much lower number. But yes, it is a catch-22 because the person, like, if they're iwi, they've never had contact with the immigration system, they've never applied for anything, they don't have the A number and they don't know what it is, right? But it's often on family and friends to try to figure some of that out, okay? So one thing that you can do is tell the family, okay, if this person calls again, the most important thing that you can do is get the A number, right? That can speed things up by a whole week, believe it or not, okay? So that's a really important piece of information you can share with them. Sometimes you may have access to that information. So if the person has filed a petition, maybe you even filed the petition, then the A number may be on something that they've filed already. Okay, so you can actually go back through and find whether it's an NTA or green card application, whatever it is, and you can find it on that document. If you do have access to the notice to appear, you can look at it that way, but that's more rare. In general, you're telling the person to look at the ICE paperwork, even if they don't read English, and look for a 9-digit number. And then many times there's also a bracelet that someone is given when they get put into a jail or a facility, an ICE facility. It kind of looks like a hospital bracelet if you get admitted to a hospital. And it's going to have the person's name. It's usually going to have a number that's related to the jail or facility that usually has less numbers, like 4 or 5 numbers. But almost always the A number is on there as well. So, yeah.
This probably varies greatly from like detention center to detention center, but is it typical for them to be given multiple chances to contact family? Like what, do they get phone calls or opportunities to connect with family?
It's whether or not they're free or not that is more difficult to know. So they should get like 1 free phone call. Some facilities do get in trouble for not doing that. Especially during COVID, there was like a real big push to make sure that everyone got at least 1 free phone call and like a free legal call. All jails and detention centers do have their own system for non-free phone calls. So there's a variety of different private companies that provide these services. It's almost always very expensive. There's a detention center where I have a couple clients right now out in Washington that it's like 21 cents per minute, which is actually not bad, but so many family members can put money on the person's commissary. That's just the term for usually money that can be used for phone calls, outbound phone calls, as well as snacks, medicine, sometimes long sleeve t-shirts, that sort of thing. And so that can also be very tricky to figure out what is that process. What is the website to put the money on? What is the calling system that you have to give your credit card to? It's a really bizarre mess. So if someone navigates that, they can make phone calls usually at particular times of day. And as long as they have the money on their cards, they can make as many phone calls as they want. They're not confidential. So legal calls are different. So again, if you get an attorney involved, that's great, in part because the phone calls are usually free and they're gonna be confidential for someone to talk through the issues in their case. But to answer your question about how much access do people have once they're detained to just talk to anybody and try to get in touch with people, it's very difficult. Depends on the facility how difficult. Yeah.
Do they get like visits, family visits or something?
So the vast majority of the facilities aren't doing, that I know of, are not doing family visits anymore. This really changed during COVID. There's already kind of a shift towards doing these like bizarre like video things where basically you go into the facility and you sit down and you can talk to the person via video. So like if you don't have otherwise access, then you can at least kind of see the person. A lot more facilities went into that direction. It really depends. There are some facilities that still haven't lifted COVID restrictions and so don't allow anyone from anyone inside the facilities. So it really depends. A lot of these facilities are so far away from the communities where people get detained, though, that it's very difficult to get to the facilities even if people wanted to.
So what is like the processing time looks like? Like when they get the notice to appear and educate, what is the timeline? Like how fast are these cases processed? And what would be a good time to file a bond? Like immediately, or should we like wait like months, or like what is the timeline?
So from the notice to appear to the first preliminary hearing, which is called a master calendar hearing, which would be the first opportunity for someone to request a bond, is supposed to be 10 days. It is not always 10 days, sometimes it's a couple weeks, but that's what they're aiming for, is 10 days. If someone gets a lawyer very quickly or knows to start gathering evidence, which again, like if you run into people very early on, you can be like, start gathering your evidence immediately, right? That can be a big help in terms of speeding up the process. If they have the evidence or if they have an attorney who's already filled out a bond petition, then you could make a bond request at that first hearing, and some judges, some courts provide bond hearings at that first hearing. But it really depends. You know, there's additional master calendar hearings after that when relief applications need to be filed, et cetera. Those usually happen for some courts like every 2 weeks, sometimes it's every month, depends on the court's docket. There's no real way to answer your question about when is an ideal time to file a bond. I usually answer that by when you have as much evidence as possible to make your application as strong as possible, right? Because if you want both a bond and a low bond, then you need to have a strong bond petition. But that's going to be a case-by-case, scenario. So again, why it's great to try to get an attorney involved early. Speaking of, so who are we trying to get these cases to? So we want to try in these cases to give a warm referral, meaning not just like the list that the court gives out of like legal service providers that are likely overrun with phone calls and may be capped at their caseload. You might get lucky and get a case placed with one of those legal service providers, but you want to be able to figure out what other private attorneys that you might look at in the area, especially if you're in a area, like a remote area, a rural area, or if the detention centers in your area are like hours and hours away. That's one of the problems with the detention system, is that the detention centers are not close to lawyers. This has been improved somewhat throughout COVID, because many of the immigration courts have turned into WebEx courts, and so immigration lawyers have more access to being able to represent people without traveling 5 to 7 hours to go out for a bond hearing. So that helps, but you still need to try to find the right person. And remember, time is of essence, right? If you want to try to get your bond petition as soon as possible, or if you want to get an asylum application on file and get your asylum merits hearing as soon as possible. So since time is of essence, we want to try to find the right person. So here's my guidance on who to look for. The best case scenario is you want a removal defense immigration attorney, so someone who does immigration court representation regularly. Maybe they also do family petitions and adjustment of status applications. Maybe they also do a little bit of employment, but they need to be someone who does immigration court representation regularly. If they don't already, and we call that removal defense. If they don't already do removal defense, doing detained removal defense is going to be a big, steep curve. Okay? So if you know an immigration attorney who only does work before USCIS and has never set foot in immigration court, they're not your choice for referring this person, even if they're really sympathetic, even if they speak Spanish, even if they're a really good attorney otherwise, right? You're going to be wasting your time because ultimately that person is probably going to say, I just don't have the expertise to be able to do that, and I don't have enough time to learn how to do that in this moment, okay? So you want to look for someone who is already doing immigration court representation and ideally who has a detained practice. Either maybe they just do like a few detained cases every year, that's plenty. Maybe they're like me and they only do detained cases, even better. But either way, that's the specialty you're looking at, okay? Depending on the area, there may be nonprofit legal service providers that you can contact, and because you already know some of these systems and you know how important the time is of essence because of this presentation or because of your own experiences, you might be able to talk to someone at the legal service provider and get a consultation for them faster than they would or faster than if a family member would. So that's where you can kind of like leverage your privilege as partially accredited representatives and try to connect them to that legal service provider. Okay, hold on. There is an Immigration Advocates Network. If you Google that, it'll pop up and there's a National Immigration Legal Services directory. You can search by detention facility and legal service providers will pop up. Also, the legal service providers, if they've done a good job in their profile, it will say whether they do detained removal defense or not. So this is your first stab at like checking to see, okay, who is, in terms of nonprofit legal service providers, who are the ones that I might contact? You might still have to do a phone call or two and ask, like, do you actually do detained removal defense, or do you have funding for detained removal defense right now? But that's one place to start in terms of nonprofit legal service providers. If you're working with someone who needs low bono or pro bono representation, that's gonna be your best shot, okay? If you have someone whose family can pull together some money and really wants to move quickly, maybe they're at risk of losing their job, maybe there's a health issue at home, maybe they're gonna like be evicted, all sorts of things pop up when people get detained. If they want to do to hire a private attorney, then you're usually looking for a small removal defense firm. They might do some detained work as well, but in general, when you're looking at their websites, you're mainly looking for removal defense in big, bold letters, okay? You may still find that some private attorneys who do removal defense don't want to touch detained cases, but you have a much better shot. If you look at people's websites, and I do this myself, you're not alone, but if you're like looking at attorneys' websites and it only says, you know, naturalization applications, family-based immigration, employment immigration, then they're probably not going to be who you're looking for. Your second best option, like I've said here, is looking for a removal defense attorney who doesn't practice detained representation, especially if they do crim-im. Okay, so if there's someone who's going to immigration court and they're very used to making immigration or arguments about the immigration consequences of criminal offenses, that even if they haven't done detained rep, they at least have the expertise to do the types of cases that you may be referring to them. And you might be able to, again, use your privilege as partially accredited representatives to say, hey, I know you haven't done a detained case yet, but this one's really sympathetic. Could you please talk to this person, right? You might at least be able to get a consultation done, okay? Last but not least, if there's no other options to go to, I think your question over here is, who do you look for? So there, like I said earlier, there's no like network of people who just do detained work, who just do crim-im work. But there are some big national organizations of lawyers that do have member directories and that at least have resources and training within them that they could learn how to do this. They may not be able to do it on your timetable, but they have resources that they could connect to learn how to do this. So one of them is the American Immigration Lawyers Association, AILA. On their website, there's a member directory and you can look up based on location. Sometimes it will give a little profile, at least about like whether they do removal defense. So that's one way to look. There's also an organization called the National Immigration Project of the National Lawyers Guild. Either way, if you call an attorney's office and you're saying, okay, do you do removal defense? Yes. Okay, and then you're trying to figure out, like, is this a credible attorney, or is this someone who's going to like prey on your client or the client's community? Then you can ask, are you a member of AILA or are you a member of NIPNLG? And that can be a little bit of a way to just determine, are these people serious or not? There are some serious attorneys who are not members of these groups, but it's a basic litmus test. Okay, so that's what I suggest in terms of warm referrals. I'm conscious of the fact that sometimes referrals are just not possible. Okay, it can be really sad. It can be really difficult to talk with a family member, a pastor, a community member, and say, you know, yes, I do immigration work day to day, but I can't help you, and this is a really complex situation, and I don't even know any attorneys to refer you to, or all of the attorneys I've contacted have said no. This is not an uncommon experience. So the first thing is to just know that and try not to hold on to a lot of guilt or like an undue sense of responsibility around it. This is a huge policy issue that the United States government has, you know, made decisions about who to detain and how difficult to make it to provide them legal representation. We could provide every immigrant with a lawyer, right? We do not, right? So these are big systemic issues that you can try to push in other ways, but in the moment, know that sometimes you're just going to have to say no, and the best that you can do is explain some of these dynamics, okay? Even just witnessing this part of the process can really make a big impact, though, so I don't want you to underestimate that. If you really can't find an attorney, a couple things that you might consider doing is one, to whoever was asking about phone calls. Each detention center that ICE works with has its own like little website on the ICE website that gives an overview of like how to make phone calls. Sometimes it will give links to the commissary system, and especially for non-English speakers, navigating that can be difficult. So if you have time, you could try to obtain that information for them so you can ensure that the family members and the detained individual have contact with one another, maybe even help them set up the commissary account. So that can be something that you can provide. Sometimes there are also pro se guides. So there are certain nonprofit legal service providers who have created guides for like the bond process or applying for asylum, and they have them in a lot of different languages. One of the most common one is the Florence Project in Arizona. So like earlier today, I literally just Googled Florence Project Bond Pro Se Guide, and one popped up. It's like a 20-page guide that walks through in very basic language, noting that many people have low literacy or maybe speaking English as a second language. And then they also have one in Spanish. Various other guides exist as well. So even if you want to like print out that guide at your office and hand it to the family member and say, you should mail this to your loved one, or you should read this. You can even try to figure out the mailing requirements for the detention center and mail it yourself. If you mail it yourself, you can write legal mail on really big letters, and it's more likely to get to the person if you mail it with legal mail on it than if a family member mails it, because all mail that comes in and out of a facility is going to be screened. So those are a couple things that you can do, and that may make you feel like you've provided some assistance, but also may make a big impact. Okay. All right. Yeah.
Talking about typos.
Yeah.
Here's a hypothetical.
Okay.
Let's say if you have a client next to you, you did like, and this may be a terrible example because I'm just thinking of it. Let's say you did an island trip for a family member who is sponsoring or establishing a relationship. You already filed your paperwork with USCIS. Meanwhile, as it is pending the application, let's say you have received the receipt notice, but your application is pending. Meanwhile, the person that this person was sponsoring is detained.
Mm-hmm.
Now they're in the detention center. And if you do not represent detainees, you refer them out and look for those options. What do you have to change through USCIS process? Like right now, the person's physical address has changed. Now they're detained, so their facility address has changed. The question, I think it's not on I-130, but if the question is, has this person ever been in removal proceedings, which you might know earlier?
Mhm.
Now it's yes. So do you amend those how does that process look like from ourselves? And if we have filed a G28 for the detainee, now you no longer represent them because they're in the detainee, but you still represent them for I-130 purposes and USCIS purposes. Like, how does it affect from where we have signed and we are still like, what can we do through USCIS process?
Yeah. Well, I don't do that type of work, so I'll do my best to answer it. In terms of, yes, you can amend your applications. You may want to wait and see what happens with the detention, if the person bonds out before you make those amendments, because a lot can change very quickly in the detention landscape. I mean, even just where they live or where they are detained can change multiple times during the course of someone's detention, even if they're only detained for like 2 months. So I wouldn't be super quick to like make that sort of amendment. I'd probably make the judgment call of like how long it's been pending, the likely adjudication time, that sort of thing, and ideally make all of the amendments at once. Just mostly because USCIS is terrible and they lose a lot of stuff, right? In general, you don't want to be submitting multiple petitions. I hate ICE and I hate the immigration court, but I hate USCIS more, if you haven't been able to tell. I would much rather deal with ICE or an immigration court than USCIS. So you guys are all doing God's work by dealing with them. What was the other part of your question? So in terms of the I-130, it really depends on whether the detention of the person is going to like change their ability to move forward with the application, because you might be able to continue your rep, especially if it's just at the I-130. If it's a one-step and you're doing the I-130 and you were gonna, like, the person was gonna consular process later, or you were gonna, for whatever reason, like they couldn't pay the fees or something, you were gonna do the I-45 later. If the person bonds out, you might be able to continue at least the first part of your representation. And then if the person has committed a crime or the case has gotten more complex, you might have to refer out the second part. If it is drastically changed during the middle of the case and the person is no longer eligible, I would talk to like your supervisors and various folks to decide like how to withdraw the application. But in various circumstances, like the difference between withdrawing an application and like just having USCIS deny it, like there's all sorts of judgment calls that people who do USCIS work are probably gonna make better judgment calls than I would.
So, sorry, just to finish this quickly. Will our communication with the client who is in the detention facility be considered legal representation? So, even though this is not related to their detention representation, but related to immigration representation, so will our phone call count as the free phone call, or will it not be, even though it is legal?
So it's not considered like a legal phone call in the way that you see like the police call on like a sitcom or something. It's not like that. So you could definitely talk with the client and explain, for example, if you're going to have to withdraw or what's going to happen with the I-130. That you should be able to. You are a legal representative. You should be able to have a confidential call with them, but it's not going to like replace them being able to talk to a detained removal defense attorney. Yeah.
My question is about the attorneys that we use. Are we concerned, or are those attorneys concerned at all about state bars and like if our person is detained across state lines, but they're only on the bar in Minnesota, do I need to worry about that at all? Or?
Nope. Very good question, but nope. So immigration law is a federal type of law. So immigration lawyers can practice in any of the 50 states as long as they are barred in one state. So that's like one thing you don't have to worry about when you're trying to find an attorney. You don't have to worry about their bars. Yeah, good question. Yeah.
So I worked on an NQRP team for a couple months with Care Coalition in DC. It might just be my own misunderstanding, but they're like the only people who can get like a free legal rep.
Yes.
So then how would we navigate if someone came to us and like suspected that their family member might be like incompetent to represent?
Yeah.
How would we navigate getting them the mental health evaluation to get that?
Yes. So what's your name? Mac. So Mac is talking about like a teeny tiny exception that is actually a lot of people in the country, but is like this very nuanced area of immigration law that I happen to practice, so I can answer your question. But like, this isn't a huge takeaway. If you want to like zone out for a second while I answer the question, that's okay. So if you know or have a reason to believe that a person is incompetent or has like a serious mental health issue or a developmental issue, traumatic brain injury, something like that, you can actually, whether or not, if the person gets an attorney, you can flag that for the attorney and the attorney can flag that. However, NQRP is the one circumstance where they can be appointed an attorney. The key is they can't already have an attorney. So if you were trying to assist the family and say like if the family is coming to you and like frantic because this person who barely understands how to like make change or get to the bus or something like that is detained, then what needs to happen is for there to be a TPN, which is a notice that the person noticed that there may be competency issues. So you could submit a letter to the immigration court even though you don't do immigration court representation, because the letter is not considered representation, it's just a notification, and anyone can make that type of notification. A family member, a friend, the detainee themselves, you, an attorney, whoever. So you could assist in that way by making that letter. It has to go to the immigration court that has jurisdiction over the person. Yep, good question. Okay, we're running out of time, but I think we have time for like one hypo. So let's see if this one's a good one. Yeah, okay. So imagine that one of your clients, we're gonna call her Rosa, who recently submitted a petition, so kind of in the circumstance you were describing about, calls you first thing on a Monday morning and sounds really panicked. And she learned that her nephew Carlos had been arrested by ICE after he was driving home from a party on Friday evening. So the first thing to notice about this is that it's happened very quickly, okay? The person has only been detained for maybe 2 days or 3 days, and we'll see if he's detained. But the earlier that you can find out about something like this happening, the better, because you can do a lot more early on. So Rosa's sister and brother-in-law, the young man's parents, are frantic as the whole family is undocumented and from Nicaragua, where country conditions have worsened since 2018 because of political protests against the Sandinista-controlled government led by Daniel Ortega. The family has been anti-Sandinista for decades. They are devastated to think about him being deported and in danger by their own government. No one has heard from Carlos since he called his mother Monday morning and said something about ICE detention. So our questions here are, what are the questions that you ask Rosa first? And then what are you gonna try to explain to Rosa and maybe do? Okay, so let's start with the first question. What questions would you ask Rosa? Yeah.
More questions about the actual arrest.
Mm-hmm.
Where was the arrest? What were the circumstances around that?
Absolutely, absolutely, yep. Yeah.
What's their A number?
Yes, exactly. Do they know the A number? Which, because Rosa is a green card holder, she might know what an A number is. So that's exciting. Yes, absolutely. What's the A number? And maybe some of the other information if they need to look up the online online detainee locator. Which what are the other ways to look up someone other than the online? Yes. Exactly. Perfect. What other questions?
This is a question, but also a question for you.
Mm-hmm.
Sounds like it could be a candidate for asylum. If they're applying for asylum and removal, I want to know how long they've been here, but is that requirement still applicable in removal?
Yes, unfortunately. So yes, 1-year deadlines matter. So yes, thinking about how long has Carlos been there is going to be an important one for sure. Yep. Yeah.
Verify that he actually got arrested by an ICE officer.
Yes. Absolutely. So where is he actually? From this information, you don't actually know whether he's still in like a county jail in criminal custody or whether he's in immigration custody. Okay, and that's one of the first things you want to try to figure out, because if he's not even in immigration custody yet, he may not even have an A number, right? If he came in EWI, for example, we don't know that. But we want to try to find out, especially since that happened so recently, right? So if he gets picked up, arrested Friday night, we're going to assume if he's gotten picked up after a party that it might have something to do with alcohol, it might have something to do with substance abuse, right? The potential types of arrests, there's other things. Someone could have gotten in a fight, but like that's one natural thing to think, right? So my gut instinct is going to be that we're probably talking about a criminal arrest. And that means he could still be in criminal custody. He might not be in immigration custody yet. So that's one thing to think about, because if he has a name number yet, or if I just try to put his full name, date of birth, and country of origin, which Rosa may have, if I try to put that in the online detainee locator, he might not show up yet. He might still be in process, going between the county jail and immigration custody. Okay, so you want to reassure Rosa, even if he's not showing up yet, he may still be transitioning. We should look again tomorrow. Call me again tomorrow. Yeah? Okay, what is something you'd want to explain to Rosa?
Like what kind of jail he may be going to and where he may be being transferred to.
Absolutely, yep. So where potentially is he going to be? And that could be really reassuring to just like know, to be able to like look up, like what's the address of this place and how far away it is. Yeah?
Sometimes if they're detained by the local police, well, I'll just say this because this happened at our office. I used to work for an attorney that used to be both.
Yeah.
Sometimes it's good to let them know it might not be best to pay the bond at the local office, because the second they pay the bond, the ICE agent would want to pick them up.
Yeah, we haven't talked about that, but that is a very good point to explain. So basically, if someone has a criminal arrest, and especially if they got arrested pretty recently and they already have a criminal bond, which might be $500, might be $1,000, typically, as soon as they pay that bond in the criminal process, they will get handed over to ICE if it's not a sanctuary jurisdiction. So they won't actually get out, even if their criminal attorney or public defender has told them they will get out. So that raises a lot of confusion. So sometimes it's better for someone to stay in criminal custody and not pay a criminal bail and actually fight a criminal case to avoid getting put in ICE custody, because then you sometimes end up having to pay criminal bail and an ICE bond, which is a real bummer to have to tell people. Okay, well, you guys have been so great. I really appreciate you chatting with me, because I didn't even have to go through all my hypos. I did want to just leave you in our last 3 minutes with a couple of things to think about. If you are feeling like after this presentation that you would like to learn more about ICE detention or even advocate to end detention, you as partially accredited reps know a lot about these systems, which then can be leveraged in other ways of advocacy, even if you're not representing detained individuals right now. Okay, so I'd like to just encourage you to do a couple things. The first thing is to know where the detention center is closest to you. There's a great interactive map that an organization called Freedom for Immigrants out in California has put together. You can literally put in your address and it'll pop up where the detention centers are closest to you. So even having that knowledge will make you more knowledgeable about the detention system than about like 95% of America. So that's the first thing you can do. There's a great organization called Detention Watch Network that advocates for the end of immigration detention and has a really great campaign called Communities Not Cages. They're a great follow both online and on social media. You can also join that network as a member and learn a lot about their advocacy. They do a lot of policy advocacy as well around legislation and do several advocacy days per year. So if you're interested in like connecting with other advocates who are doing this work, DWN is a great place to connect with. If you have a local nonprofit bond fund, you can do several things to support your bond funds in the area. Even doing a fundraiser, doing some volunteer hours. I know you all have way too much work as it is, so you probably don't have a lot of time for volunteering, but it's a great way to very directly help people get out of detention. And then lastly, if you are like, what you've heard here today sounds like a complete shit show, maybe we should change it, then welcome, join the club. But there's a couple pieces of legislation that have been proposed that would actually undo a lot of what we're talking about. So one is the New Way Forward Act that would actually undo the legislation in the INA around mandatory detention, so it would make pretty much everyone eligible for a bond, which just think about how long it took me to explain all of the different systems where people aren't eligible for bond. So just that quick change would be like life-changing for so many people and families. I would say the New Way Forward Act is a little bit more progressive, really looking at like the root causes of problems in detention and really aiming towards minimizing detention. The Detention with Dignity Act of 2023, though, is also very important. It would improve the system that we have and really make sure that there's a lot more protections for people who are detained. So if you're someone who likes writing letters to your congressmen or senators, definitely encourage you to look those up and send a letter their way. Both have active, lobbying efforts going on. So I want to thank you all for what you do, and thank you for your attention and all your questions. It's been great talking with you today.